laches, where the federal equity jurisdiction is exclusive and is not exercised in aid of a legal right, state statutes of limitations barring action at law are incapable and are in the absence of any state statute barring the equitable remedy in the like cases. The federal court is remitted to and applies the doctrines of laches as controlling. Page 309 U.S. 289 U.S. Supreme Court 1940. Gibson, subsection 44. And when it is shown that such person have used money by them so held in trust in the purchase of any property, real or personal, taking the title in their own name, a court of chancery will impute to them an intention to fulfill their obligation, namely, to make the purchase for the benefit of the person entitled to the use of the consideration money. And they will be decreed to hold such property as trustee for the benefit of the parties whose funds were used in the purchase. Equitable assets. Equitable assets are all assets which are chargeable with the payment of debts or legacies in equity, and which do not fall under the descriptions of legal assets. First Story Equity Jurisprudence, subsection 552, Joseph Story. Those portions of the property which by the ordinary rules of law are exempt from debts, but which the testator has voluntarily, free will, own volition, charged as assets, or which being non-existent at law have been created in equity, Adams, EQ 254, ET SEQ, they are so called because they can be reached only by the aid and instrumentality of a court of equity, and because their distribution is governed by a different rule from that which governs the distribution of legal assets, 2 Fonbell, EQ B4P2, PT2, C2, subsection 1, and notes Joseph Story, Equity Jurisprudence, subsection 552. Private trust law, statutory versus equitable, two completely separate jurisdictions. History of private trust law, 14th century crusaders, king's conscience over the land use, fiefment, and rights to profits. Palmery, Perry, Gilbert's, Luen, elements of trust, intent, purpose, parties, res, methods of formation, intent, manifested intent. What is the intent? Purpose, lawful purpose. Is your purpose lawful? Is your manifested intent in good faith, good conscience, and for good reason? The next is parties. Who are all the identifiable parties? And what are their titles? Reachable and beneficiary is identified alive. All right? Res, formation, delivery, transfer, verbal, fraud, concealment, conveyance, contract agreement, will, statute, silence, acquiescence, admission, consent, acceptance, endorsement, appointment, failure of disclaimer, notice, actual or constructive endorsement declaration. Such a trust may be created by deed or may rest entirely in parole, or may be partially in writing and partially in parole. 1966, Florida Appeals, Frazier versus Frazier. Edward C. Hallback Jr., Gilbert Law Summaries, Trusts, author of second and third reinstatement on trust used widely in the courts today. Special note, implied trusteeship without consideration. Gilbert, subsection 274. Notice to and acceptance by trustee. If an effective transfer has been made, a valid trust exists, even if the trustee has not been made aware of it. That's the beauty of a trust. Neither notice to nor acceptance by the trustee is essential to formation of the trust. Rest third subsection 14. Gilbert, subsection 276. The trustee acceptance is presumed unless the contrary is shown. The trust cannot be forced upon him, however, and he is free to disclaim the trusteeship any time prior to accepting it. Rest third subsection 35. Subsection 276 through 282, Gilbert's. The failure to inform the intended trustee had no significance and that an irrevocable trust was created. Let me tell you the power in that right there. When you went and you ascertained what you believed to be a mortgage, a loan, and you issued a promissory note, and the fella or the gal that took it instantly became a trustee. But if you lack the knowledge, it says in the Bible, my people shall suffer for their lack of knowledge. You didn't realize that you were creating a trust relationship between the trustee of the principal, which is the bank being the principal, the trustee being the agent and agency. And by giving them something, you were actually giving them something of value, so you were engaged in fair trade, equal exchange. Mattered not to you what they were going to do with that note after the fact, but the fact of the matter remains that they did monetize that note. They were made whole and in full, and now they're coming after you for an alleged promise made after they destroyed the original intent of the document, liberating the debtor. Acceptance presumed. Subsection 276, the trustee's acceptance is presumed unless the contrary is shown. The trust cannot be forced upon him, however, and he is free to disclaim the trusteeship at any time prior to accepting it. Rest third subsection 35J. Disclaimer, subsection 277. If there has been an effective transfer, but the trustee disclaims before acceptance, the trust does not fail for lack of a trustee, which means even if the trustee disclaims it. Let's just say you were dealing with a sales agent, you handed them the promissory note, and that trustee disclaims the trust will still not fail for want of a trustee. And when we go to court, we're going to probably find out that the CFO or the CEO then became and fills the seat as a fiduciary trustee. All right? So don't get discouraged when somebody says, well, I disclaim the trust, I don't want to be part of that. The trust still does not fail for want of a trustee. The trust does not fail for a lack of a trustee. Rather, unless a court holds that technical title vests in the trustee, the result may be that title remains in the settlor subject to the trust until a substitute trustee is appointed. See above. Few actual cases have faced a controversy over this matter. See, retraction, subsection 278. Once having disclaimed the trustee is usually not permitted to retract the disclaimer, although courts may be permitted to retraction where no harm or prejudice will result. Carter versus Carter, 184A, period 78, Pennsylvania, 1936. Trustees' obligations, subsection 279. Once having accepted the trust, the trustee is bound by all of the fiduciary obligations imposed by the law and by the terms of the trust. What are the terms of the trust, ladies and gentlemen? We talked about it briefly yesterday. The terms of the trust are found in the indenture, and the indenture is the law of the trust. All right? And not only is the indenture the law of the trust, but it absolutely must be abided by, as the grantor's settlor wishes must also be complied with. Okay? Trustees got some big shoes to fill and got to stay within the lines. Imposed by law and by the terms of the trust, and can be held personally liable for neglect. See infra subsection 611 through 620. Resignation alone does not relieve the trustee of these duties and responsibilities. Ordinarily, the trustee must petition the court for a replacement. Even if the trust instrument expressly authorizes resignation, the duties of one of who has accepted the trust continues until a successor is in place. REST period 3D subsection 36. Acceptance relates back to subsection 280. The trustee acceptance normally relates back to the time the trust came into beginning, in ab initio, from the beginning. All right? Duties prior to acceptance, subsection 281, although for many purposes, ergo, accrual of beneficiaries' rights to benefits, a trust becomes effective at the time it comes into existence, ladies and gentlemen. Was your birth certificate, your bill of lading, was it a special trust deposit placed within the state, probated by a state registrar, a probate officer, a probate judge, if you will? Did that create an estate for which trusts were then multiplied off of and created and brought into existence from? Absolutely. Are you entitled to it? You bet. But only if you have the knowledge. A trust becomes effective at the time it comes into existence, ladies and gentlemen. The trustee normally has no fiduciary duties until acceptance of the trusteeship, expressly or implied, occurs. Notice to and acceptance by the beneficiary, subsection 282, notice to the beneficiary that the settlor intends to create a trust or has created one is not necessary for a valid trust, ladies and gentlemen. Did you just hear what I told you? It is not necessary for them to tell you they created a trust for your benefit. Notice to and acceptance by the beneficiary, subsection 282. Notice to the beneficiary that the settlor intends to create a trust or has created one is not necessary for a valid trust. Acceptance by the beneficiary also is not essential to trust formation. REST 3D subsection 14. Res corpus trust property. Method of formation of the trust relation. No technical words are needed. Gilbert, special and private versus general and public. Are you making special deposits or general deposits? Are you a special private American national or are you a general U.S. citizen on the public side? Okay? Special and private versus general and public. It's that simple. Trust created by an actual transfer of legal estate in property from one to another, or as it was afterwards called, by transmutation of possession, the equitable jurisdiction of the Court of Chancery, 1846. Special deposit versus general deposit. Banking. The suit is plainly one of the equitable cognizance, the bill being filed to charge the defendant as a trustee for a breach of trust in regard to a special deposit argued March 14th, 15th, 1889, decided April 8th, 1889, Bank of Memphis versus Eliza Walker. The general rule is that every person who receives money to be paid to another or to be applied to the practical purpose, to a particular purpose to which he does not apply it, becomes a trustee and is answerable to the owner of the money as for a breach of trust in regards Interborough Council Corp. Now, your promissory note is equivalent or the same as money. And if they misappropriated the funds, ladies and gentlemen, then they are in breach of trust as fiduciary trustees. Handle your affairs. Stick it to them? Was it your intent to create a promissory note for which you would be the implied surety and handle the affair? Did they go above and beyond their call of duty and alleviate you of that implied suretyship by converting the note and being paid multiple times over? You decide. You be the judge. You figure it out. It ain't that damn hard. A trustee is bound only as he accepts the trust, but the trust is not invalidated by his failure or refusal. While his disclaimer frees him from any obligation to execute the trust, the rights of the beneficiary are in no sense dependent upon his acceptance. A court of equity will never suffer an express trust in regard to which there is no question to fail for lack of a trustee. Beach 1897, Trust and Trustees. The writings, meaning the declaration of trust, are but evidence. The trust is anterior and independent, and the rights which the courts regard are those that spring from the creation, not the mere proof of the trust. McVeigh versus McVeigh, 1887, Supreme Court, New Jersey. Now, when we first started talking, ladies and gentlemen, we were talking about the enumerated versus the unenumerated. We were talking about the written versus the unwritten laws. All right, and this is where trust comes into play. 5 primary offices of trust. You've got the grantee, grantor, settlor, trustee, beneficiary. You collapse the trust, you got grantee absolute. All right? Grantee, modes of acquiring property. Grantee is the holder of absolute title, both legal and equitable. Marriage, descents, escheats, occupancy, olivin, prescriptions, adverse possession, operation of land registry, forfeitures, bankruptcy, alienation. Alienation. One mode of alienation is by mere written agreement. Another is by deed. That is, by a writing sealed and delivered. A third mode is by matter of record. But whose record? Are you going to use their record, or are you going to use your record? What do you feel is going to be more beneficial for your beneficiary? Until a deed is accepted by the grantee, which means don't let those bankers run off with your damn grant, with your deed. They do it all the time. They go, sign here, initial here, sign here, thank you. And they leave it on the table, and you go, is that all? Yep, that's all. You can leave now. And they leave it on the table, and you walk away, and you never read it, and you never take it home and look at it. But there's a document in there that you need to accept from the grantor to the grantee, and you need to accept it as such, and you don't. So you abandon the property. The bank whisks it away. For no man can make another his grantee without his consent. And a deed made to a man with all requisite formalities and even entered in the public registry will be null if not afterwards accepted by the grantee. Did you accept your deed? Did you accept the title to your property, or did you abandon it and walk away? And now it's an imperfect gift for which equity will not aid a volunteer. A delivery always implies an acceptance by the person to whom the delivery is made. And although where a deed or a mortgage or an instrument purporting to be such is properly acknowledged and recorded, the presumption is that it has been duly delivered to the grantee or mortgagee, and that it is in legal effect what by the record is purports to be. Yet such presumption is only prima facie evidence, which means it can be challenged at any time and may be rebutted by parole or other evidence and shown never to have been delivered, which means an imperfect gift. When a grantor causes an acknowledged deed conferring substantial benefits on the grantee to be recorded, there can be no doubt that it will afford prima facie evidence and even strong presumption evidence of a delivery to an acceptance by the grantee. But such presumption can be overcome by evidence that no delivery in fact was intended and none made. Deeds creating a trust delivered to a third person or recorded by the grantor have been upheld, although there was no actual acceptance by the trustee, the GGT. The person named as trustee never heard or saw the deed until long after it was recorded, and then refused to accept the trust or in any way to act upon it. The court held that his refusal was immaterial, saying, although a trust may never have heard of the deed, the title vests in him, subject to the disclaimer on his part. Such disclaimer as a transfer of the equitable interest to a third person, a trust cannot fail for want of a trustee or by the refusal of all the trustees to accept the trust. The Court of Chancery will appoint new trustees. Lawyer's report annotated. Grantor settler is transferring with intent and purpose legal and equitable title. Trustee is only legal title. It is not a derivative legal title such as custodian, bailee, nominee, agent, executor. Again, it's only legal title. Beneficiary holds equitable title. All right? Note, legal fiction can only hold titles by characteristic, which means they're colorable, ladies and gentlemen. In the legal realm, everything is fiction. Everything is colorable. Everything is prima facie. Everything can be challenged on the legal side. And if you don't put it forward, then you waive your right to do it. All right? And private citizens only hold titles by nature, equitable by nature, real property. We're not talking about lot, block, parcel ID number, zone improvement projects. We're talking about land patents, ladies and gentlemen, equitable by nature. And a title by nature extinguishes a title by characteristic in a court of equity. Executory mortgages, equity version. A court of equity may compel a specific delivery to the pledger of a note or mortgage held by the pledgee after the payment of the debt to secure which such notes or mortgage was pledged on the grounds that the retention of them by the pledgee was in violation of the trust. The action to compel such delivery, and in the meantime, to restrain the negotiation of the securities, the promissory notes, the bills of exchange, your signature, is such an action as was formally denominated equitable. In all such cases, courts of equity will interfere and grant full relief by requiring a specific delivery of the thing which is wrongfully withheld. I.e., the note with all its proceeds, rents, issues, and interest due to the pledger. The subject of trust is a matter of peculiarly of equitable cognizance. And we suppose a pledge of personal property creates a trust in respect to such property. Thus, a fiduciary relationship is created between the parties in respect to the pledge, from which arise various obligations and duties. Wisconsin's report, case determined in the Supreme Court of Wisconsin, Volume 14. Mortgages are equity. It is also an established doctrine that an equity of redemption is inseparably connected with a mortgage. That is to say, so long as the instrument is one of security, the borrower has, in a court of equity, a right to redeem the property upon payment of the loan. This right cannot be waived or abandoned by any stipulation of the parties made at the time. Even if embodied in the mortgage, this is a doctrine from which a court of equity never deviates. 1877 Supreme Court of the United States, Puig versus Davis, P-E-U-G-H versus Davis. What is valuable consideration? Do any of you guys really comprehend what it is? What did you receive for what you gave? Loan application, notice of approval, they are holding credit assets, grant deed, lien, mortgage contract, notes, clogging provisions, clouding provisions, landlord-tenant relationship. Although the mortgagor is equitable owner, yet the mortgagee is more than a trustee for him, for the trustee is not allowed to deprive his sesticate trust of his possessions, but a mortgagee may assume the possessions whenever he pleases. If there is no agreement to the contrary, and in point of possession, the mortgagor is tenant at will, even in equity, for a court of equity never interferes to prevent the mortgagee from assuming the possession. Cote verse on mortgages, 379, page 324 and 379. COOTE on mortgages. Commercial is simply shadow title, not claimed in the private. Titles that someone did not perfect their private title to. Equity will not complete an imperfect gift, and equity will not aid a volunteer. Shadow titles. Palmery, subsection 47. The ownership of the equitable estate is regarded by equity as the real owner, and the legal estate is, as has been said, no more than the shadow always following the equitable estate, which is the substance. And it reminds me of the little cartoon Peter Pan, where he's running around chasing his shadow, and he's trying to tie his shadow back to his feet, all right? He's trying to merge equitable and legal title and keep his evil shadow from doing evil things. Except where there is a purchaser for value and without notice who has acquired the legal estate. The doctrine of merger 101. When legal and equitable title vest in the same individual entity, when whole title is achieved, the trust terminates. All right? It is no more. It collapses. Here's many ways merger happens. Legal and equitable title vest in the same entity. A higher right and a lower right over the same subject matter. The lower right is extinguished. When an easement is acquired by the encumbrancy, the easement is extinguished. Here's a big one. When a debtor becomes the beneficiary of the debt is extinguished. Ooh, that's a good one. Let's say it again. When the debtor becomes the beneficiary of the debt is extinguished. Are you the beneficiary? I sure hope you are. I sure hope you are. But only you can decide that. Only you have the power. There ain't no agent and agency that can tell you otherwise. You have to acknowledge and accept it. When one withdraws from general deposit and redeposits on special deposit, the same subject matter, the relationship change. The lower relationship is extinguished, i.e. the debtor-creditor is extinguished, and special confidence relationships are left. Special trust deposits, trust relationships. When a beneficial right by nature of a living man claims the beneficial right of a legal fiction over the same subject matter, the higher right wins by nature, because rights by nature trump rights by characteristic, which is legal by characteristic for all intents and purposes, equitable by characteristic. Your natural equity by nature is your trump card. When legal title by nature of a living man is assigned to a shadow title, aka legal title by characteristic, the lower quality legal title by characteristic is extinguished. When lawful consideration is tendered, the credit fiat title is extinguished. When you're no longer using Caesar's money and you're using real gold and silver, and it doesn't take what you guys think it takes. When you start using lawful stamps according to the Stamp Act to pay your transfer taxes, You're going to start to see that things aren't what you've been told. It's not near as damn hard as you once thought it was. And you can simplify if you just let these words resonate in your mind. When a claim in exclusive equity is recognized, the at-law claim is one second. I have to pronounce this word correctly. Because the last thing I want to do is not know exactly how to pronounce this. Let's find out.
Annihilate.
Annihilated. So, when a claim is in exclusive equity is recognized, the at-law claim is annihilated. When an equitable asset of substance is moved to a legal title by characteristic, the legal title is extinguished. Your signature can be noticed to be an equitable asset. Those assets that can be charged in the eyes of equity, all right? When the trustee becomes a beneficiary, the duty is extinguished. When notice of an equitable claim over the same subject matter is not rebutted by proper notice, Gibson's waiver, consent, priority, at law, a trustee, a man cannot be his own creditor or debtor. Hence, when he acquires an estate subject to a charge in his own favor, the charge will, in law, merge in the estate. Van Omer's estate, 25 PA subsection 234, 237, corpus juris secundum estates. Also, you can be a debtor to your own estate. George C. Bagley versus McCarthy Brothers Company, June 23rd, 1905, Minnesota Reports, volume 95, book page 289, merger. A merger at law is defined to be where a greater estate and a lesser coincide and meet in one and the same person, in one and the same right, without any intermediate estate. The less estate is immediately alienated, or in the law phrase, is said to be merged, that is, sunk or drowned in the greater. Gilbert Law Summaries Trust, subsection 159, where a sole trustee and sole beneficiary are one and the same person. The result is a merger of legal and equitable title, defeating the trust and creating a fee simple in the person. Interest must be exactly the same for the merger to occur. Rights are said to be merged when the same person who is bound to pay is also entitled to receive. This is more properly called a confusion of rights or extinguishment. 52, Gibson, subsection 55, suits and chancery, subsection 55, where there are equal equities, the first in order of time shall prevail. He who is prior in time is superior in right. The maximum is sometimes misunderstood and misapplied. Its true meaning is this: as between persons having equitable interest only, if their interests are in all other respects equal, priority in time gives superiority in right. And in a contest between persons having only equitable interest, priority of time will give superiority of right, provided there is no other sufficient ground of preference between them. For if the equities are equal, one of the parties has, in addition, the legal title, then another maximum would apply. Where there is equal equities, the law must prevail. In a court of chancery, in a conflict of equities, the party having the superior equity will prevail. And if the equities are equal and neither party has the legal title, then priority prevails. And if no priority, the defendant prevails. Grantor-grantee relationship. Absolute title passes. Both assets and liabilities, the entire ledger. You cannot force someone to be a grantee, but a grantee with status, lawful consideration, and notice can force an operation of an assigned title to be an absolute conveyance. But you can make someone a grantee and make yourself a grantee where operations of law is otherwise determining the relationship. All roads for the private citizen lead back to the plaintiff, sealed, ex parte, bill in equity for declaratory relief, federal equity practice in District Court of the United States, governed by maxims of equity. Article 3, subsection 2, subpart 1, chancellor is what you're looking for. Remember, your court of equity, your exclusive jurisdiction of equity is held on the four corners of your paper, period. Record creation due process, actual and or constructive notice, notary paper, registration county, certified mail, private, restricted, in personam, in rem. All right? Unregistered equitable claim, Palmery, subsection 659. In other words, if a subsequent purchaser for a valuable consideration has put his conveyance upon the record, but at the time of his purchase was affected with notice that there was a prior outstanding but unregistered conveyance of the same premise from the same grantor, would he be protected by his record notwithstanding the notice? Or would the notice operate like the constructive notice arising from a registry? To postpone his own interest to that conferred by the prior unregistered instrument. This question was presented to the English courts of chancery at an earlier day and was settled by them in accordance with the general principles of equity, and their decisions have with great uniformity been adopted and followed by the American courts. It is the established doctrines that a notice of some kind of an existing prior unrecorded conveyance operates like the constructive notice arising from a registry to postpone a subsequent and recorded instrument if a subsequent purchaser, even for a valuable consideration, had received notice of a prior unrecorded instrument, then he cannot acquire or retain the precedence from a registration of his own conveyance. His conveyance, though recorded, is subordinate and postponed to the prior unrecorded one of which he had received notice. Private account number. Mail yourself a simple registered mail and pay it using a money order and stamps. Use a green card with a 3811 and sign for it. Signature as grantee without prejudice. Make copies and store. Record in county. Notice of deed of acceptance and acknowledgement of the RR number, the registered mail number for sufficient valuable consideration, signed signature, guarantee or grantee. Public, I'm not going to get into this much deeper. That's how you create your trust identifier, your trust res number, your trust identifier through the registered mail number. All right. Private notice of priority interest, private trust expression, GGT, grantee, grantor, trustee. In support of NOI, notice of intent, Palmery, notice of interest, Palmery, subsection 1265, a prior equitable lien created by a deposit of title deeds is superior to all subsequent claims of mere volunteers and of the parties acquiring rights under the depositors with actual or constructive notice of the liens. Gibson, subsection 55, priority of right. Show of cause why I do not hold superior equitable or legal title to the property, and that it is not a trust, or be it resolved, you have 10, 20, 30, 40 days to disclaim the trust. Notice of interest affidavit in support of the GGT, grantor-grantee-trustee relationship. Subsection 44, and when it is shown that such person have used money by them so held in trust in the purchase of any property, real or personal, taking the title in their own name, a court of chancery will impute to them an intention to fulfill their obligation, namely to make the purchase for the benefit of the person entitled to the use of the consideration money, and they will be decreed to hold such property as trustees for the benefit of the parties whose funds were used in the purchase. Subsection 43, hence, it is the passing of the consideration and not the form of the contract that in equity passes title. And whatever the form of the transaction, if no consideration passes, in equity no title passes. Mortgages. Dear bank, show me the consideration you gave me for all the things I gave you, and that it was equitable, and that whatever you gave me was equitable in nature. Gibson, subsection 57. As men living by their own labor and property, no man is presumed to part with either without receiving or expecting an equivalent in value. Hence, whenever one person has obtained either the labor or property of another, he should pay or account therefor, unless he can prove it was a gift. And everything, ladies and gentlemen, is handled as a gift. Because when you start to look at the IRS forms, you quickly realize that everything is a gift and estate tax. Isn't that funny? So you're gifting it all away because you're not learned. You're not researching. You're not getting your nose in the books. You don't see what they're doing. And so whatever injury one person does to another or another's property or capacity to labor should be made good. Palmery, subsection 685, nature of the equities. The equitable interest created by a trust or by a contract in rem made upon a valuable consideration is superior to the equity arising from a mere voluntary transfer, a mere gift, or from a mere judgment lien. In contemplation of equity, the interest created by a trust or by a valid executory contract of sale, or by a valid contract giving rise to a lien, or by an act in connection with such a contract constituting a lien, as for example a deposit of title deeds, is a real beneficial interest in the specific thing itself, an interest which is property or analogous to property. Now I want to make sure I'm saying this word right here. I believe it's analogous. Let's just see here.
Analogous.
Analogous. All right. Primary or original relations being those that exist between the original parties to the transaction. Secondary or derivative relations being those that exist between an original party and the privy of the other original party. And 3, collateral relations being those that exist between the privies of the original parties. Certificate of special deposit, a natural title representing the legal estate, delivery of deed to trustee, certificate of appointment, certification of trust. 2 witnesses, notary in box, border, notice of tolling of time, notice what date the trust vests, statement of interest, notice of the establishment of trust under the formation involving but not limited to your confession, acceptance, non-disclaimer, endorsement, delivery, transfer of legal title, parole on the phone, agreement, express or implied. That's your trust. Now you got to be able to articulate it. Demand for performance and accounting signed by beneficiary of the trust. Notice of breach of trust for failure to perform or failure of performance. Enforcement. Object. Sealed. Ex parte. District Court of the United States, bill in equity for declaratory relief, notice of laws of the case under Maxims and Gibson's 64 sections. First 64 sections in Gibson's, second edition. Go check it out. I believe it was mastered in 1907. Captions, parties, jurisdictions, cause of actions, claims for relief, facts for affidavit, notice of evidentiary hearing. Declaratory relief is appropriated when a litigant needs direction from a court before taking future actions. Such direction will afford the litigant relief from uncertainty or insecurity. See American Household Products, Inc. versus Evans Manufacturing, Inc. 139 F Superior Court 2D 1235, 1239 NDA 2001. The object of the declaratory judgment is to permit determination of a controversy before obligations are repudiated or rights are violated. Okay? As many times pointed out by this court, its purpose is to permit one who is walking in the dark to ascertain where he is and where he is going, to turn on the lights before he steps rather than after he has stepped in a hole. Cox versus Athens, Reg. Med Center 279, Georgia Appellate Court 586, 594, 631, SE2D 792, 799, and 2006. So essentially, your declaratory judgment, ladies and gentlemen, is your discovery on what your trajectory is, what your rights are, what the rights of the other party is, and you're going to get that firmly established before you take your course of action so you don't find yourself in trouble, right? Okay. Declaratory relief refers to a judgment of a court which determines the rights of the parties without ordering anything be done or awarding damages. A declaratory judgment is a judgment of a court which determines the rights of parties without ordering anything to be done or awarding damages. The power of the court of equity to retain jurisdiction to give complete and effectual relief is well established, and it follows without any serious controversy that the court may make such further orders to give effect to a declaratory judgment as shall seem meet and proper. Exclude public and press, petition the court to show cause why my private citizen rights should be commingled with those rights of the public enemy, belligerent, and rebels. Or be it resolved, this cause shall proceed sealed and ex parte, because we don't want it in the public venue. Okay? You don't want to be with the enemy, rebels, belligerents, and combatants. You don't want to be there. You're not going to find your remedy there. All right? There is no at-law remedy to be had. Federal Equity Practices, American Technical Society, Library of American Law and Practices, Equity Procedures, 1919, book page 64, section 81, dual system of jurisdiction. To the contrary, the federal courts keep entirely separate actions at law and suits in equity, as much so as did the courts of common pleas and the high courts of chancery in England 100 years ago. This is affected by the device of having two sides to the court, the law side and the equity side, and between them there is no possible connection. If he wants or needs equitable relief, he must depart from the court on its law side and enter it by the equity door on the other side, where he will be heard by the same judge acting as chancellor. Ladies and gentlemen, I've experienced that. And I'm talking literally, figuratively. It was reality. I didn't walk through the normal door. I walked through the other door on the other side of the court. All right? Oh, no, Derek, we're not going in that door. Come with me. Follow me. We got to go back here. That's the deputy sheriff, the bailiff talking to me. Come on, we got to go back here. You got to come back into this room. You got to enter the court a different way. Why? I don't know, Derek. You just got to follow me. It's what I've been told I got to do. You got to come this way. Isn't that amazing? It's not just literally, figuratively, and in your mind and a manifestation. It's not just metaphorically. It's reality. All right? Newby versus Enron, 2002. The court held that the federal courts have equity jurisdiction that was exercised by the English Court of Chancery at the time of the adoption of the Constitution and the enactment of the original Judiciary Act of 1789, quoting 1928 rules, the court further noted that regardless of the merger of the formerly separate courts of law and equity by the federal rules of civil procedure, the substantive principles of courts of chancery remain wholly unaffected, entirely unaffected, untouched, unmolested, unviolated. By nature, they stand unaffected. Some of the earliest writings on equity jurisdiction of English courts emphasize the exclusive role of the equity courts over suits arising out of a breach of fiduciary duty. Equity Remedies, Palmery, Section 355, page 587. Its particular effects, footnotes numbers, 1, in Wilcox versus Wilcox, 14 New York, 575, 579, 581, it was decided that the individual judges acting in chambers have all the power and the functions which were possessed and exercised by the chancellors in chambers. Print Gibson's first 64 sections and entitle it Notice of the Law of the Case. Plaintiff with primary rights hereby notices that these proceedings shall be governed by maxims of equity, not Roman civil maxims, but American English equity maxims. And the first 60 sections of Gibson, show of cause why the proceeding cannot proceed accordingly, or be it resolved thereof, and therefore, henceforth, hereto, herefrom. Package to the court may include, but not limited to, a simple guide, not for reliance on. Title page, example, call to make an appointment with the chief clerk. Anyway, I'm not going to get further into this. I hope that this helps you guys ascend to the mind. My throat's starting to go a little haywire. I'm going to take a little break. I'll be back with you guys this morning and help give you some more insight on Palmery, Aristotle, Gibson, Bouvier. These guys were geniuses. They were absolute geniuses. And like I said, equity is wholly untouched. So for you guys that keep preaching about common law, you're in the wrong venue. Wrong venue, wrong venue.